We're live.
All right, welcome back, everyone. S59, open meeting law. We have a couple of guests joining us remotely. Kathy Feely, and who do we have over there?
Linda Corey.
Lynn, how you doing,
Good.
Linda?
How are you?
Hi.
Good. Good to see you.
Yes.
So yeah, we started taking some testimony on some concerns about disturbances over in the municipalities, and we really appreciate you being nimble and joining us on short notice. So we're just trying to get feedback, input, and insight as to what's going on out in the municipalities with some of these situations. So I appreciate you coming in, and I'll open it up to you to share with us what you wish.
Okay. We have people that come to our meetings and they accuse us of not doing things right. And we're constantly having to prove that we do it right. Like, advertise our meetings in the newspaper, it's on our website. Um, we've had 4 court cases dismissed because of this. We've got 4 more pending on open meeting law violations, because we don't offer CART, but we do offer Zoom, which they say is appropriate for what we need to do. And it just seems like we've wasted a lot of time the last 2.5 years trying to prove ourselves that we do the best we can and we do everything correctly.
I mean, this person has launched many meeting law violations against us, which the town has responded to because we haven't committed any violations. And then when we read that, those responses in our meetings, this person wants to argue with us and say that we're not right. Then he takes us to court, and the court agrees that we didn't do anything wrong, and he won't accept that. He'll come to a meeting, he'll ask to be put on the agenda so that he can come to the meeting and speak about municipal wrongdoing or some alleged impropriety by town officials, or we haven't advertised something correctly. And he'll hijack the meeting basically and take it over for 20 minutes or a half an hour. We had to institute a policy that gets read at the beginning of our meetings now, which say that you can only comment on things that are on the agenda. And we have a specific public comment time. People are limited to 2 minutes. So this individual will speak longer than 2 minutes. The chair will warn him that his 2 minutes is up and he needs to stop. He won't listen to the chair. He'll speak over the chair. And then in a case in December, we had a sheriff on site, and the sheriff had to go up to the microphone and ask this person to sit down because he wouldn't. We had a meeting recently that he attended by Zoom where he did the same thing. He exceeded the public comment time, and the chair warned him and told him that he was out of order, and he wouldn't stop speaking on Zoom and talked over the chair. And so we couldn't quite figure out how to mute him. We never had to do that before. And so he was told that he had to leave the meeting, and he said, "What are you going to do? Come down and send the sheriff down to my house where I live?" We had to adjourn the meeting, stop the business of the town, and adjourn the meeting because we could not get this person to stop. I mean, we have business that we have to conduct. We want to hear from everybody, and we try to accommodate everybody. But this particular person has hijacked the open meeting law for his own purposes, and we don't really know what to do. We would like you to help us with it.
It seems like we don't have any rights ourselves because we are public officials. And, we've got no trespass orders against us, but, there's nothing that we can do personally or here for the office.
Yeah.
I mean, the other day, he came into our office. We had to call the sheriff and we had to have the cops because he doesn't want to leave. He just requests a lot of things. He won't fill out the public records form that we have. We just don't know how to deal with this kind of behavior.
And he says that we're doing things wrong the same way each time. When we have a meeting, we send a notice down to the Caledonian Record. That is our newspaper of record. He claims that it has to be actually printed in the newspaper and sent to the radio. It doesn't have to be actually printed in the newspaper. We just have to notify the newspaper, which we have always done. And in response to these open meeting law violations that he is accused us of, we have the email that we send to the reporter at the Caledonian, and we have proved that we have done what we were supposed to do. We respond to his open meeting law violations in a meeting. He will not accept that. He talks over the select board chair and tries to argue. He will not accept that we have done it right. And he's taking a lot of our time. I mean, we're not getting stuff done in meetings because we have to respond to this man. We have to change everything. We actually had to set up a process where people have to make an appointment to come into our office now. Because if this individual comes in, they're so disruptive and they take up so much of our time that we can't get work done.
And it ruined our whole day. I mean, you know, like on the other day, we couldn't do anything else really the rest of the day because it's very upsetting to try to deal with this.
I mean, we operate in good faith. The majority of the people, I think, who live in the town of Berwick, who have elected us to our positions, are happy with what we do. And we know that, and they tell us that, and they just think what's going on at our meetings is incredible. They don't understand why it continues to happen. We understand that everything should be transparent, and we do our best to make sure that we are transparent and we don't hide things. But I think this person has his own agenda. And when that happens, the town should have some kind of recourse. I mean, the court has shown that his arguments, his claims are specious. And yet he makes them over and over and over again. And he takes us to court and he ties up town resources. He ties up state resources. If the state police or the Caledonia County Sheriff have to come to our meeting in case someone like this gentleman is disruptive, that means they can't be somewhere else to respond to an accident or a real important matter. I mean, it doesn't really make sense to us.
Yeah, I guess we are just kind of asking maybe that we have some sort of rights ourselves. You know, like we don't want to hide anything. We want to do the best we can. But it seems like there's nothing that we can do here.
I mean, if someone constantly disrupts our meeting, couldn't there be a change in the law that says if someone behaves badly, that they get the equivalent of a timeout? They can only attend a meeting by Zoom. And then if they're disruptive when they're attending by Zoom, then we can mute them so that the business of the town can continue. Because we meet once a month. Our select board meets once a month. They have a lot of things to do in that one meeting. We really can't have one person hijacking our meeting and taking up all our time so that we have to adjourn before we're finished with everything we need to do.
Representative Hengo?
Thank you very much for being here. I'm really happy that we learned that other towns are having these issues. This just kind of came up organically because another town was having an issue and someone mentioned, oh, you might want to talk to the town of Berwick. So really happy to have you here. Thanks for telling us your issues, which are similar to other ones that we have heard. My question is, could you explain what your current operating procedures are for somebody who wants to come in to see the town clerk and how that differs from what you have traditionally been doing before these disturbances occurred?
They call our office to make an appointment. And most of the time, you know, when they call us and they say they're going to be here in 15 minutes, 20 minutes, we will accommodate them the best way we can. And we do let them in. And we've done this for this certain individual. He's made appointments and sometimes he doesn't show up, but then again, he does. And then when he does, it's just not good. But I realize this is a public office. We do try to let him come in and give him what he needs. But he's never happy with what we do. So having the appointment and having the door locked has made us feel a lot better.
A little safer that he can't
Yes.
just come in anytime he wants and disrupt the office schedule and keep us from doing what we need to do. One
does
day,
it- Sorry, does a police officer have to be there when he makes an appointment to come in? Do you
They
call?
have, yes, they have offered, the sheriff has offered to have us let them know when he wants to have the appointment, and they will do anything in their power, they said, to be here with us from now on, after what happened on Tuesday.
in the past, we didn't have that. We assumed that he would conduct himself appropriately, but what occurred this week has sort of made us realize that that's not going to happen.
I mean, you can't make him do anything, which is fine, but it's just so wearing that someone is after you constantly.
Yes, I can understand that that's very stressful for the folks in your office. And could you elaborate a little more on what happened last Tuesday to cause you to want the police to be there, without naming names or anything? But could you just give us a quick rundown on Tuesday's events?
He asked for an appointment to have access to the records. He said he would be here less than an hour. He sent an email at 8:08 in the morning. We responded at 8:11 and said, you can come in at a specific time,
Which was 9 o'clock.
which was 9 o'clock. He came at 9:15. He wanted some public records. He didn't want to look at land records or things that are easily accessible. The green books once he wanted to see. So it was explained to him that in order to get a public record, he needed to fill out a public records request form. He was given the form. He didn't want to fill out the form. He started reading our public records policy and explaining to me that why he didn't need to fill out this form. I said, if you want the record, you need to fill out the form. He continued to read. I said, I don't care what that says. If you want this record, you need to fill out a form. You've filled out public records request forms in the past, and I opened the book that shows the 10 record requests that he had filled out prior to Tuesday. I don't understand why it's so hard to fill out this form. I don't have to fill out the form. If you want the record, you need to fill out the form. Then I said, I'm done arguing with you. Is there something else I can help you with? Then he asked for another record. I gave him another public records request form and said, you need to fill out this form. If you want the record, I don't want to fill out the form. Again, if you want the record, you need to fill out this form. No form, no record. The chair of the select board was there while this was going on because basically this gentleman was arguing with me for 15 minutes about whether or not he had to fill out the form. And he said, the ladies in the office don't have time for this. You need to leave. Well, then he wasn't going to leave. And the chair of the select board said he needed to leave and he refused to leave. And they pretty much were in each other's face about whether or not he was going to leave. And the chair of the select board told Linda to call the sheriff. So we called the sheriff. They were on a detail somewhere else and couldn't come right away. They advised us to call the state police. So we called the state police and we waited 40 minutes because they're busy elsewhere doing serious things, not trying to remove somebody from our office. The gentleman waited for 40 minutes for the state police to come. And when they came, they escorted him outside. That was the end of that.
Thank you very much for explaining all of that. I did not know that that happened, and I'm sorry that that had to happen to you. It is really disturbing, even just listening to it. Are both of you full-time or part-time employees? How
Full-time.
often is your office open? 5 days a week?
5 days a week from 8 to
Okay.
4, and we're both always here, and our assistant is here as well.
Thank you. So has anybody from the public said to you that this having to ask for an appointment is convenient or inconvenient to them? Because I'm thinking about me like dropping by my town clerk's office just because I'm driving by and I need to ask them something. Have people expressed that this is concerning to them?
They have, some of them have, of course, a lot of people are aware of our situation and most understand. And like I said, if you're driving by and you stop and you see, you gotta call us, we will probably let you in, pretty close to that time that you think you need.
Right. I mean, we have a doorbell that you can ring and we'll let you in.
Yeah, we let you in and we'll find out, what you need. And, most people need a copy of a tax bill or a dog license, something that doesn't take that long. So we do try to accommodate everyone, even the person that, gives us such a hard time. We try to give them an appointment in a timely manner. But it just is not working well.
Thank you. Appreciate that. I have one last question. Do you have like a doorbell camera, some kind of security system that you can see who's at your door?
We don't have the camera yet at the door, but I can see who's at the door
It's a
when they
glass
ring it. It's a glass door when they ring our doorbell.
So we know who's there.
Yeah, we do know who's there.
Thank you.
Representative Boyden?
I'm wondering if you've seen a decrease in participation in your public meetings, your select board meetings because of these disruptions.
Sorry, what did you say?
She thinks we want to know if
sorry.
participation is reduced.
I
I
don't,
don't think so.
no, I don't think so.
Okay.
No, because most people, when they call to be put on the agenda, I check with the select board chair. And he authorizes it or he doesn't allow it, so. They know they can come or they don't need to on this matter that they think they had to.
I mean, I don't think people worry about him being there. They're not afraid of him or anything like that, but it's
Right.
just when he tries to take over the meeting and people kind of look at each other and say, oh, again. Because it's been happening for a long time.
So it's actually an inconvenience and not a physical threat, but it's an inconvenience to the folks trying to do business.
Right. Right, yes, because he always wants to talk about how we don't do things right, or how he just wants to talk about his feelings, and we're all wrong here. Nobody does anything right. Never.
But I will say Tuesday was scary. And he has told other people that he has a gun, that he's packing. We don't know if he is or not. But the demeanor on the chair of the select board and this gentleman on Tuesday was very disconcerting. And I was worried that they were going to come to blows. I mean, to be honest, I thought about getting in between the two of them. And then I thought I might get smacked. So,
Yep, I got up and then I sat back down because I'm thinking, what am I gonna do,
right.
Because we were upset with all this situation like this.
He just refused to leave and was in the chair of the select board's face, basically, make me. And no one wants to put hands on anybody. No one wants to argue with anybody. We just want to do our jobs and
try to give this gentleman the information he wants, but it's impossible.
right. And we try to treat people in a respectful manner. I mean, he asked for an appointment. He was given an appointment 3 minutes after he asked for that morning. I mean, I don't know how much more we could have done. And he knew perfectly well that we had a public records policy, which meant he had to fill out a form, which he had done in the past. So again, we don't really understand what the issue is, but
I mean, we do have a pending case with public records coming up
the court.
in the courts because, he, like I said, we give him what he asked for, but then he says we don't give him what he asked for. So I don't know how to make that right. I don't think I can.
And that's why we have a form where you list what documents, what information you need specifically on that form. So then we have a record of what you asked for. You have a record of what you asked for. When we provide you with that information, we would have that person sign for it. So we have a record they received the information they asked for, and they have a record that they received the information that they asked for.
But he won't ever sign, really. We have information here for him that he requested for public record stuff, and he won't take it.
You won't take it.
So he'll put the request in, you execute that, and it just goes he just it doesn't follow up. He doesn't pick up the documents that are requested. I
Well-
mean, I'm just reiterating what you said, but I just,
Yeah,
Yes, we have
Yes.
a big envelope here that our attorney sent him with all the records that he requested, and because it came from the attorney, he refused to accept it.
1 second there. Did he give you a rationale as to why he will not pick it up? Because it was specific to the attorney producing the documents?
He has an argument about whether or not the attorney has the right to represent the town. And he
Okay.
claims that she doesn't.
so,
So if it comes from her, he won't take an email from her unless it suits him. He won't accept mail from her, so she sent it to our office. We tried to give it to him, but if it's from the attorney, it's not from the town, because she doesn't represent the town. Again, that's an argument we can't win, and we have learned that it's just a waste of time to argue with him, because he won't accept what we say, so
so we just need, I guess, maybe the law a little bit to be on our side in a situation what are so difficult to deal with.
Representative Pisano, thank you for your patience.
Yes, you said that he's been doing this for a while. Did he do it with the previous town clerk, Priscilla Aldrich as well?
no, he didn't live here then. He's only been a town resident for about 2.5 years.
Okay.
Representative Morgan.
Is this individual, ladies, is he on law enforcement's radar in any other way, shape, or form, whether mental health issues, other law breaking things, or is this just the only thing you're aware of, that he is just ornery and constitutive in this manner only?
Right. They know about his disagreements with the town officials, town employees. But I don't think he does any other law breaking.
I'm just kind of curious because if there was additive things that if you engage them, but obviously you're already engaging law enforcement, I'm sure they would be looking at it collectively if this was not his only
Right, right.
transgression, so to speak.
If you Google his name in Bustia, you'll see that he has a lot of lawsuits. He
Against
likes to
Government.
use the legal system. And he's
Right.
using it against us.
Yeah.
You know, Kathy's been here 20 some odd years. I've been here 20 some odd years, and we've never had a situation like this in our whole entire
Never.
career here.
So does he have lawsuits pending outside of the municipality, outside of yourselves? You're saying there were other cases, are they isolated to the municipality, or is this or?
He sued an airport in another state. He was sued by another state for misrepresenting himself as an engineer. I don't know if it's a hobby or.
Okay, no, thank you for that. Rep. Pisano, did you have your hand up again?
Yeah, I just wondered how much money the town has had to pay in legal fees because of this gentleman.
Well, so far this year, we just received our bill for April. We will have paid $22,000 for legal representation. I think the bill for May will probably put us at 30,000, which is what we budgeted for the year. And I would expect if this continues that we will be in the $50,000 range. So a penny on the tax rate is about $41,000. So more than a penny of the town tax rate is going to go towards paying legal fees for this gentleman.
Okay, so
That's
those
a lot of
numbers, those costs were specific to the legal
They were.
engagement with this specific individual.
Just this specific individual.
And that's not counting last year's.
Last year, we had quite a bit too.
Do you have an idea what that number is?
I believe it was $17,000.
17?
Mm-hmm.
Okay, thank you. I wasn't sure if you said 17 or 70. I wanted to make sure I understood.
Oh, please, not 70.
No, and that's why I wanted to verify that. Yes. I mean, it's still a lot of money, but
well,
Representative, I'm sorry, I had another hand up from a member, Representative Hooper.
This is Mike. Have you approached anybody about a no trespass order for when you get to the point of inferring you have firearms and
Well,
We've asked the state police about it and we've asked our lawyer about it, and because it's a public building,
Yeah, well,
I mean, and I don't know how you would verify someone actually has a gun without patting them down, and he has the right to have a gun. It's just the idea that he tells other people in stores, we have heard that, the people in the office should be careful because he's packing. Now, no one's signed an affidavit to say that, so, but it's been related to us. So that's a little nerve-wracking. I mean, during election season, you're not allowed to have a gun in the town office when we have elections going on. But again, how would we know without actually having someone pat him down, which would probably be a violation of something?
Rep. Stone?
Hi, this is more a question for Ledge Council. Fear of imminent harm can justify a protection order, so wouldn't this potentially qualify as a fear of imminent harm to get that?
Tucker Anderson, Legislative Council. I don't want to comment on anything that could be taken as legal advice for
Okay.
individuals involved, but based on what you heard yesterday and my knowledge of this area of law, you would need an actual articulated threat against an individual. And it sounds like, based on what we just heard, that these are.
So in
It doesn't
Vermont
mean that's
law,
standard.
fear of imminent harm does not justify a protection order.
We should probably, if you want answers to this, dive into the actual statute around TROs and what these standards that the court.
It just seems like we're dancing more with that than we are with people actually coming in wielding a weapon, like knock on wood, hope that doesn't happen. But a lot of the testimony we've taken seems like it's more of that fear of imminent harm versus an actual act. Right, so that would be helpful if we could get that information at some point.
Representative Nugent, and then hang again.
Yeah, just to, add to that, I don't think it's the fact that he has a gun that's a problem. It sounds like it's that he's bringing that up, and it's why is he bringing that up in that context? And that, I think is pretty clear.
Representative.
Yes, I was just gonna kind of bring this back to why we asked you to come in. It's more the public disturbances and the interruption of public business that was the reason we brought you in. And regardless of what he's saying he has or other people are saying he has, he's not threatened you with a firearm. So
No.
the point of your complaints against him, and correct me if I'm wrong, is that he has gotten to the point where he is so insistent on disturbing the public meeting or the business of your office that you cannot get your work done and you cannot get the public's business done. Is that correct?
That is,
Yes.
that is.
Thank you.
Before this happened, we would never have asked just a regular person to make an appointment to pick up a tax bill or register a dog. Since COVID, we have always had lawyers make appointments because sometimes it can get very busy in here, and we want to be sure that the lawyers can do their work and not, have too many people at the tables trying to look at the land records at the same time. And they've been very supportive of that, and I think appreciative of it, because there's not like 4 or 5 people in here all looking at the land records at the same time. But it never would have occurred to us to make the general public have to have an appointment to come into our office. That has never been the way this office has been run. It's always been open to everybody. Come in whenever you want, chat with us, get whatever you need. That's the way we want to do it. This is very distressing to us.
I'm sure it is. And I really feel for you. It's not at all comfortable to be trying to do the job that you're elected to do and to have this kind of behavior hanging over your head all the time for so long. You said it's been going on for a couple of years now.
Yep, a couple of years
Yeah.
now. Yeah, it's like no matter what we do, it's never going to be right. And what can we do?
And he seems to be escalating. I mean, never in a million years would I have expected him to be in the face of our select board chair the way he was on Tuesday. That was That was disturbing.
So I just wanted to ask you about that timeline on Tuesday, just real quick again. So he emailed you at 8:08 a.m.
Yep,
Correct. And you responded at 8:11.
I did.
Okay. And you scheduled the meeting for 9 a.m.
Mm-hmm.
He arrived at 9:15.
Yes.
Okay. I just wanted to make sure I had that timeline correct. That was very brisk response.
Mhm.
So
But we do try to be accommodating.
We
and-
do.
And, then with him, after what happened with, not filling out the form and him and the select board, it's like 40 minutes he's standing at the counter waiting for the state police, and it was just so uncomfortable,
It was.
Nobody said anything, you try to go about your work a little bit, but obviously you can't concentrate. And
I mean, you're all upset because of what's happened. By the end of the day, we were both exhausted just because of what had happened in the morning.
Representative Nugent?
I guess I would like more information or to talk more about just for their safety's sake, and maybe this comes up in other public areas, but to me, when someone says like, it sounds like, hey, I'm really mad at you, you're not doing what I'm asking you to do. I've come in here 15,000 times asking for assistance, and by the way, I have a gun. So like, to me, if the law means that you have to say, I'm going to hurt you with the gun for that to be an actual threat, I guess that would be helpful to know, but it seems like there should be something.
and he doesn't say that to us.
He hasn't said that to us.
Yeah,
I
that
don't
was,
think he's.
It's been
that was like
related to
hearsay
us.
from the public.
Oh, okay.
Yeah.
That
That must-
I mean, still concerning, but it wasn't
It
direct.
is concerning,
Like,
right?
And our lawyer did possibly ask if someone could sign an affidavit saying that he had said that to someone in a local store. But again, who would want to sign an affidavit that would turn the focus of this gentleman onto them? And not too many people would want to do that, I don't think. So it's alleged but not proven, I guess is what you would say.
No, thank you. Is there anything else from the committee for these fine municipal servants?
Totally non-related question, just inquiring minds want to know. Linda, are you related to Ronnie Hackett?
No, I'm not.
Just
I don't think I
curious.
know Ronnie Hackett.
Thanks.
Okay, well, thank you very much. We will reach out to you again if we feel like we need to hear from you further.
Okay.
I do want to leave you with the knowledge and maybe a little bit of comfort that we are going to be very attentive in the near future to trying to figure out something within our purview that could help out scenarios like yours, because you are not alone out there.
Yes, that's
and
what we hear.
Yeah, we've already heard from one other municipality, and we have apparently a couple of other municipalities that are interested in sharing similar stories with us. So
Okay.
thank you so much for the work. Thank you so much for staying with the work. And I'm so sorry you're dealing with this right now.
Well, thank you for listening to us.
Yes, we appreciate it.
Yeah.
We just want to be able to do our jobs and help everybody, including this gentleman. We just haven't quite found the right way to do it, I guess.
Thank you.
Thank you.
Thank
You have
you.
no idea how much we appreciate you. Okay, well, we'll be in touch if and when we
Okay.
need anything else from you.
It sounds good. All
Thank
right.
you.
We will sign off from the meeting now.
Thank you, ladies.
Thank you.
Thank you.
All right, team. That was a lot to digest. Do we, I mean, I feel like we're all in the same sort of like vein of like trying to understand some of this more and what there is as mechanisms. Rep. Waters Evans, and Stone.
So I feel like when we were just listening to those witnesses talking, that there were like a lot of things that seemed like crimes that were happening, right? Like, I'm not sure that there are things that should be addressed through open meeting law changes or changes to this particular thing. But I recognize that this situation is very it's untenable for them. I really admire the way they kept saying, like, when they were signing off, she said, we want to do our job, including this gentleman. Generous to call him a gentleman. He doesn't seem that gentlemanly, but it seems like their commitment to fulfilling their obligation is really admirable. It's strong and that they're consistently doing the right thing. I'm just sitting here thinking none of this seems okay. None of it seems like stuff that should be allowed under the law. But I don't know if this is the law that needs to be altered.
Rep Stone, I got a copy.
I was gonna say that, like, the other day when I left here, I just kept thinking about, like, when I'm substitute teaching and there's one kid who is being a real problem and disrupting the classroom. You don't cancel the pizza party for the whole class. You figure out a way to address that child's behavior, and that may mean sending them to the principal's office. But so that's how I feel about this. Like, I feel like there is something that needs to be done to address these behaviors from these people who are acting like thorns, but I just worry that doing it through open meeting law isn't the right mechanism. And I also don't know if this is the right committee to be discussing some of this. Like, while they were talking about this, I was like, I feel like this should be going through judiciary, asking questions about, is there a way that we could adjust protection orders in this state to include some of this threatening behavior to public officials? Like, oh, we're a public building. It's like, okay, well, that shouldn't give people clearance to act threatening towards public officials, you know? So, but I don't think, I know that wouldn't fall in our committee's jurisdiction. That would fall in judiciary's jurisdiction. But it's definitely something that needs to be discussed, but it just seems like open meeting law is like taking away the pizza party for everybody because some of these people are acting viable, inappropriate.
You know, and I kind of had the same thought that this definitely touches on different areas. One of the things I was thinking, as I was thinking through that thought, because I was in the same place you are right now, is if there's a vehicle that's relevant to the judiciary conversation that's still alive, and whether or not we take a look at doing a little something here in open meeting law and then readdressing this to scale when we reconvene in January. And that's just sort of, I was trying to just line up the like, what's the capacity now to address it in a in a way that can mitigate some of this stuff. And then take a look at the broader landscape of it. Coming into that session, so. Thank you, Nugent. Oh, VL, sorry, yeah,
VL, you were
VL, hang
before
on,
me.
you are correct.
Just, and this is probably for Tucker. Section 2 of 1 VSA 312 with the right to attend public meetings. Is there language in there that protects against disruptive conduct already that we can use as a baseline to try to enhance so that there is something in there for the towns to say, this is acceptable, this is unacceptable. If you don't, they can set rules in place.
Yes, and that is something that Representative Harrison's bill attempted to target. In 1 VSA section 312, subsection H, the public is given reasonable opportunity to express its opinion on matters considered by the public body during the meeting, as long as order is maintained. So there's a proviso there that order must be maintained during the period with the public providing comments. In addition, public comment shall be subject to reasonable rules established by the chairperson. Rules have to be formally adopted before they're enforced, of course. But as long as the chairperson has established reasonable rules for the public comment, the public has to abide by those rules during the comment period. What Representative Harrison's bill did is it provided additional clarity in that subsection by adding language stating that the public body could adopt more formal rules as a body instead of just the chairperson that was specific to conduct during the comment period.
Mhm.
And consequences, including the exclusion of members of the public if they violate those rules. And when we walked through kind of the overview of what Representative Harrison's bill did, I talked about how it set expectations for the public body and public in the General Assembly's intent section. It then allowed these rules to be adopted at the discretion of the legislative body. Provided that those rules were adopted, now the public has notice of what the rules of conduct are during these meetings. And you could get to the point where a member of the public is excluded, and depending on their conduct at that point, and whether the meeting is substantially disrupted, it could lead to criminal penalties for that.
But I just want to clarify, this isn't a meeting, like what we just heard, this man rolling up to the, whatever, the office of these, that's not a meeting. So that doesn't cover, That wouldn't cover.
the office, but it did cover what he does at the select board.
correct, but it sounds like from what Lucy asked, it's not really causing disrupt, or well, it kind of is, but like, it seems like when they're alone in the office and having to look through the glass window and they see him coming up, that's when it seems like there's more of that fear of imminent threat. And I don't think they have a police officer sitting by their side while they're doing their work every day. So it doesn't cover everything, is what I'm getting at.
Right.
But it definitely
Hang on,
covers some, but
hold on,
not.
Tucker.
Tucker.
I was going to offer that they were talking a bit about the Public Records Act as well, and under one VSA 316, public agencies are also capable of adopting rules that are applicable to records requests to prevent the disruption of the business of the public agency on a daily basis. Which it sounds like perhaps the town has adopted a series of forms that are used to request the records, schedule appointments to come in during the office hours. So they've structured this out. The issue may be that there, under the Public Records Act, are no consequences for someone violating those rules, and there's no ability for the public agency to adopt enforcement that could then be applied to the individual requester. On the extreme side of this, the most likely applicable criminal statute would be criminal threatening of a public officer or employee, which was expanded bit by bit over the last 3 years to apply to threats with the intent of retaliating against a public officer or employee for conducting the business of the governmental agency.
All right, I got a line here. I'm going Hango, Nugent, Stone, Shea, Morgan.
I'm done
You done?
for now.
Yeah, so I think I forgot what I was gonna point out, but I will go back to what I read yesterday, which Tucker just reiterated, was the one VSA 312H. That is already in statute. So the chair of the legislative body has the authority to set rules and expectations. I wouldn't mind seeing that expanded to the whole legislative body. So for instance, the select board gets to decide what the rules are. That seems a little bit more of a democratic process to me than just the chair saying, these are the rules here. So that might be more palatable to people if the legislative body made the decisions on, these are the ground rules. You're going to have 2 minutes to speak. And then if you don't stop speaking, you need to leave. And come on Zoom next time if this happens X number of times in a row or something to that effect, whatever they decide the rules are going to be and the consequences. And the consequence of having to appear on Zoom is not taking away anybody's right, in my opinion. So I think that's an adequate thing for a select board or another legislative body to enforce. At some point, it may get to a criminally threatening situation. I think we have heard that in the case of Mendon, which Representative Harrison brought to us, that folks are being escorted to their cars by police officers because they are afraid to get into their cars, because they are afraid that the individuals who are in question are going to physically harm them. there may have not been a statement made by the individuals, I am going to hurt you. But there is that sense of fear that I'm feeling from some of the people who have testified and some of the situations that I know of, and being familiar with being in that situation, it is not a comfortable feeling at all. And if I felt physically threatened, I would rather say so ahead of time than experience a bad consequence and have something happen to me or someone else because they did not speak up. So I would really like to see this language allowing for rules and consequences. That doesn't take away anybody's right to attend the meeting. It just kind of alters where the meeting takes place for that person.
Okay, up next, Rep. Nugent, and then I have Rep. Marsh Evans, then Morgan. It looks like I had a cough and hand go back up again. So that's the lineup.
I think for me, I'm trying to like process this a little bit and be like summarize it and think about open meeting law and the, you know, the overarching goal of it. And then, and I don't think anyone's trying to do anything to open meeting law in terms of access to information or transparency. I think it sounds like we have these cases that are causing problems for actually the whole rest of the town and the people doing their work. And so just sort of keeping that in mind as we're looking at these tweaks and what's possible in the law right now as far as what bodies can do to regulate the behavior going on. And I think what I hear sometimes from towns and what I feel like I'm picking up in my own experience even is that they're afraid maybe to do what even they can do, because if they go outside of the law or they get all these complaints, it is going to cost them a ton of money. And if they make a mistake, it will cost them more money. So they almost err on the side of not going as far as they could, even with putting in their own rules. And it seems like they need like support and clarity and cover from the legislature to make sure that it's very clear that you can regulate the behavior of people in your meeting. And when they go outside that bounds, then there is something that you can do.
Well, I guess I'm thinking about what Rep. Hingo said about there being the opportunity already for them to do something about some of this stuff. And what Rep. Nugent just said about the financial piece of it, which is really interesting and a really good point. Are we allowed to compel people to pay legal fees on the town that's spent on revenue? I don't know it's allowed, but I was just thinking about that. Anyway, I wonder if it's an outreach issue more than an issue with this statute of letting municipal bodies know what they can and can't do and what the procedures are.
Okay, Rep. Morgan, then Rep. Coffin, then Rep. Pittsfield.
Mine's more of a commentary is, I think unfortunately what we're seeing with all of these, I can safely say are these people know exactly where the line is and they are touching their toe on it and then they withdraw just enough. So they're masters of what they're doing. Because I think, I'll bet if you checked each one of them, I could be wrong, that they know the left and rights and they are pushing, they're putting a bubble in the line, but they're not breaking it. And that's a tough one. I mean, how do you regulate that? They haven't technically done anything criminally wrong. So I just think as we sift through this, or if we sift through it futuristically in other sessions, just gotta be careful. Certainly this is unacceptable behavior, 100%. These people they know they're wrong. And their behaviors, I'm sure they know they are. They're just being, we've had from our select board perspective, thankfully, knock on wood, nothing this egregious, but we've had constantly people. I think even one time we called somebody we said, if you don't leave the beauty, we have police departments attached to the building. I'll go ring, ring, you know, we told them, get out or you're going to get out. So just as we go, my only cautionary is we gotta know that line's there. Yeah, they've pushed their elbow into it a little bit, but we just gotta, but I agree. I mean, this is problematic and it's not good and it's unfortunate. That's the word I would just say. It's more of a commentary.
Thank you, Representative. Rep. Coffin, Rep. Pisnall, and then I do want to recognize that Mr. Gill from the Land Use Review Board is here with another individual, and he had asked, thank you very much, had asked to try and find some time for them to share some perspective on another piece that we had been discussing. So I want to recognize that and also recognize the fact that we have another matter at 11 and I'd like to take a 5-minute break. So with that, Rep. Coffin.
No, mine was more almost on the line of Brett Morgan with that line in the sand that I was reading over the H 145, that commentary, some of the additions in there. And if we could just make that line clearer so people know, the town knows, the municipalities know where they can set a line and say, and the public knows where that line is if they vote on their rules. So everybody knows, okay, at this point, stop. Just to keep the meetings going. Let them do the work of the town.
I know that Maine had a similar situation with one of my friend town clerks in their area, and they passed a law and it's 17 AMRSA 751, obstructing government administration, and their law is a person is guilty of obstructing government administration if the person intentionally interferes by force, violence, or intimidation, or by any physical act with a public servant performing or purporting to perform an official function. It says here that Vermont has that law, has a similar law, but I just looked up Vermont's and Vermont's only says state political officials. So I find that. Shoot. Under chart.
Representative Pincinel, are you looking at 13 VSA 1702?
No, it is to the chart that they shared. It's 13 VSA 3001. And it's all state and local executive officers, does not apply to public health officials. A person may not hinder an executive or civil officer acting under the authority of the state or any of its political subdivisions. And the crime is up to 3 years imprisonment or a fine of up to $500. I know in Maine, this one particular clerk she had to move to another town under an alias, my property under an alias name, and she was under a protective order. She had state police protecting her home, and I mean, it was bad. This one lunatic. Right?
I would just want to clarify that 13 VSA 3001 under its express terms does apply to political subdivisions of the state, which would include municipal officers. This appears to be more of an obstruction of justice statute, and so does the Maine provision. The main language that you read out does run fairly close to another statute under Vermont law, the one that I referred to earlier, the criminal threatening statute in 13 VSA 1702, which relates to acts carried out with the intent to terrify, intimidate, or unlawfully influence the conduct of, and we'll boil down the next 17 sentences to public officers.
Hey, anything else on this piece right now? We're gonna shift over. Okay, so I think what this did was it created a lot more questions than answers.
Yes.
Right. Absolutely. All right, cool. We got consensus on that one. Okay. Janet, how are you?
Good, hi.
Take the name off.
Thank you for having us this morning. I'm Janet Hurley, the new chair of the new Land Use Review Board.
Pete Gill, Executive Director for the Land Use Review Board.
And Pete's been talking about this with you already, some of you. But as the Land Use Review Board is now 5 full-time professionals working full-time at the business of the board. We are committed to being a public-facing board. In fact, we are meeting twice a week, whereas the previous Natural Resources Board maybe met once every other month. So we are meeting an open meeting regularly. We are traveling around the state to hold our meetings rather than being sort of this nameless board somewhere in Montpelier that nobody knows. And we are committed to developing a community engagement plan as a covered agency under the EJ law. So we are really committed to being more public facing than this board has ever been in the 55 years of the Act 250 program. Now that we are 5 full-time members with professional backgrounds that complement each other to do the work of the board, what we are finding is that we can't work collaboratively together during the work week outside of an open meeting. And so because most of our staff is dedicated to administering the Act 250 program and not necessarily supporting the work of the board, we don't find it is tenable to ask staffers to produce the minutes and to run the hybrid meetings and to post the agendas and then all the things that you have to do to plan for an open meeting for the board to work together 40 hours a week or more. So what we're hoping for is some carve out that allows the board to do work collaboratively, reserving all decisions and milestones for the open meeting, but to allow us to discuss strategize that sort of thing in between regular open meetings. And there are various ways that we can do that. We don't want an exemption from the open meeting law like the PUC has. We don't feel it's necessary. We just need a little bit of flexibility in terms of how we can work together as a full-time board.
Yeah, again, I think I mentioned this last time that I was in here too, is just, thinking of corollaries with other state entities, secretaries will work collaboratively with their staff. This staff is 5-member professional board and they're being hamstrung in terms of their ability to collaborate in an effective way, whether that's collaborating on working document, Google style docs, right? And all having input into that process as it's being developed, or whether it's just email exchanges. We're being very careful in terms of how we operate so that we meet the open meeting law. But what you're hearing from the board, and why I really wanted to make sure that Janet could be here today, is that you can understand kind of the practical limitations that are being probably unintentionally put on this new board as they're trying to develop this land use process, new land use process for the state.
Right, and the new board was devised to be, this range of professionals that could collaborate together effectively as a full-time board, and from different backgrounds. And I think, in order to meet that intention, it would help to have an avenue by which we can meet outside of an open meeting as a board. What we've been doing is each board member has taken on some of the tasks as to be the spearheader of those tasks. And so, we're kind of in our silos to some degree, working alone. And then we bring things to the board at regular intervals and have discussions in the open meeting. But it would certainly be more efficient, effective to be able to, have some relaxation of those open meeting law triggers for this board.
More effective, efficient government, I think.
Yeah.
Particularly with this board, as it's got a big charge, in terms of setting up this new land use process as we went through last time. And it would be, it would be unfortunate to have the board not be able to have those conversations in a way that can move this process forward expeditiously and still in an open way with the public.
And as Pete said, we are being careful. Each of the board members has these tasks and we are moving forward with them. And we are conferring with one another on a one-on-one basis throughout the week. And in such a way that we aren't considered a committee, just sort of, so we're doing work and we are trying to collaborate. I think it would just be easier if we had some avenue by which we could collaborate without making final decisions on anything, without making policy outside of an open meeting.
I know there's been floated like working groups and that type of concept. I mean, something like that could work for the board, but again, this is a 5-member board. So right now, if you're talking, you'd be talking about 3 people that would constitute a quorum. And it would really be, we've got a planner, an engineer and an attorney, another 2 planners on the board, and we want them all to be able to bring their experience and input together on processes.
Right. Questions for these folks? We have 4.5 minutes.
Thanks. Can you give me a concrete example without giving anything away about, I don't want you to pinpoint a specific permit or whatever it is, but can you give me an example of some of the ways in which you're collaborating and some of the things that you would like to collaborate on, more like a specific topic or what that looks like? Because it's so big.
So one of the things that we are tasked with is to develop a structure for taking in regional plans from the regional planning commissions and approving them. And that's something that this program has never done before. And so we need to set up guidelines to develop those procedures. And we need to set up guidelines for the board to review the plans and to to criteria by which we need to make a final determination on whether that regional plan meets the statutory requirements, basically. And there are a huge, number of elements and whatnot that go into those regional plans. Title 24, sets them out for the regional planning commissions. And now the LURB's job is to make sure that they've done that in a way that allows us to issue an affirmative determination of compliance. So that having the lawyer among us, with the planners among us, to work at setting up all of those guidelines and steps in those processes, reserving for the open meeting, and we have talked about this throughout the open meeting, but we do need to sort of do some of this work without the benefit of collaborating with those other professionals on the board to some degree.
Yeah, so let's say for that particular example, they're working on a guidance document. One of the items might involve wastewater. And so they're wanting to check that box. Janet and one of the other board members are meeting to kind of work on that guidance together. And they say, oh, it'd be really helpful to have the engineer's perspective on that. That's got to, you know, then we've got an open meeting that we've got to warn on that type of thing. Or it might be really great to have the lawyer's perspective on that. Oh, we've got to wait to put that onto open meeting. So just to have that ability to collaborate kind of in the moment, you know, you're walking around the halls and you see one of your colleagues, you can collaborate on different things and you're not thinking about what that quorum number might be or something like that. To be able to do that in our kind of virtual world is really important for the board. The same thing with a document that they might be working on in that way, to be able to have that as a shared doc that the board can work on in a collaborative nature is just really important, I think, to make this work go smoothly.
Rep. Nugent?
I'm not sure if this is a question or for you and or council, but my understanding, and I'm trying to understand like what is possible now versus what the intention behind the law. And so what does not require open meeting law or warning or fall under that, in my understanding, is when you're gathering like background information or you're collaborating on putting background information options and strategy together. Like when you're doing the staff work, even if you are a board that is also made up of staff, but it's the decision itself and the deliberation about the options that falls under open meeting law.
Yeah,
think
and I
it's broader
think,
than that.
yeah, and I think we have to police ourselves when we're outside of open meeting to make sure that we're not conducting the business of the board in a deliberative fashion, basically. And it's really, it's hard to work efficiently when you're constantly trying to police yourselves too. So that is, you know, that line is hard to draw in a way that it allows us the freedom to just work together.
You may start off a conversation in a way that you've framed that meeting as we're focused on this and it's outside of the open meeting law. And you start that conversation and you want to get into something that maybe would bleed into that open meeting law. And that's where then you've got to cut off the conversation. Again, it can be rather inefficient that way when, again, this is this board is structured as staff of the board doing that work.
Okay, we are at time. Thank you very much for the input. I believe Representative Pango had a PSA.
Oh, yeah. So Autumn kindly made us a bill spreadsheet for all of the bills that have passed out of this committee that we've either been reporters on or following. Would appreciate it if we could schedule some time next week for a committee meeting on the record to talk about the bills that we have been following. So if everybody could kindly look at that spreadsheet and see where your bills are, and then be prepared to come back to us next week and let us know what's happening with them. Thank you.
All right, folks, we are going to take a break.